We're running a bit late, so without further ado, I want to introduce this panel on the ICJ and Time. It might sound a bit more theoretical, but we have presentations that will refer to both theory and practice and look through the lens of time, the jurisprudence of the ICJ. So we will start with Conor McBain, who is a lecturer at the University of Ulster. And his presentation is entitled Between Precedent and Present, the International Court of Justice as a Producer of History.
Joseph. Right, thank you, Matina, for your kind introduction, and thank you to James and Christian for the opportunity to return to what always feels like my intellectual home here at Glasgow. It's a pleasure to speak alongside Sara and David as well. I think if one imagined this panel and its topic is a tasting menu, I would undoubtedly be the soup course, both because temporally I'm speaking after Matina, and because my offering is, I dare say, the lightest in terms of volume and flavour when compared to the rest of the menu. So in that spirit, I'm going to try and keep my remarks quite brief. It's something of an academic caricature that one can overpromise in an abstract or proposal, sit down to read and think and try to pull together a work in progress and find oneself hopelessly adrift, or in other words, fail to produce the paper one imagined writing. And that's where I found myself in the last week or two as I tried to capture what I wanted to say on this theme of time and the ICJ. My planned experiment of trying to situate the ICJ with a sense of historical agency in methodological debates between professional historians and international lawyers. So rather than continue to try to push water uphill, I've decided earlier this week to throw out the first version of that experiment and start over, and I'll explain why in a moment. My original ambition for this paper was threefold. First, to explain how the ICJ acts as a producer of historical understanding. In other words, how its judgments as products of legal and factual interpretation produce narratives afforded truth value as historical statements, and to situate the ICJ as an entity with historical discursive agency and therefore ethical responsibility for how it engages with international law's often problematic past. The paper's closely related second aim was to reflect on how the ICJ has exercised that agency, particularly how it integrates the use of historical argument in its decision-making during cases. This ambition was influenced by accounts of the weaponization of historical argument in constitutional litigation before the United States Supreme Court. Its third aim was to situate the ICJ's historical agency within international legal scholarship's turn to history over the last 3 decades and the so-called method wars between international lawyers and historians that have taken place since. Overall, the first aim was reasonably straightforward, albeit the point doesn't seem especially controversial. However, as I'll explain, the second and third aims proved more challenging. Regarding the first aim, as Thomas Guterres points out, legal work inevitably requires a positioned engagement with the past, thus producing or contributing to the production of historical knowledge. Similarly, Matthew Craven has observed, a decade into the turn to history, that international lawyers all trade in history, all engage with events and situations arising from particular historical junctures, and a consistent feature of that engagement is not merely a concern to translate what we know of the past into history, but an idea of history into law. He also observed that international lawyers' engagement with history could be loosely grouped into 3 trajectories. First, histories of international law's collective teleology, or stories of origins, development, progress, or decline. Pick your narrative, but that's the kind of broader theme of it. Histories of international law's role and the role of international lawyers in social fields like politics or economics. And third, histories within international law, which describe the place that historical events or persona occupy within substantive discussions of law and the role they play in arguments about law itself. So this third genre, which takes the form of treatises, legal opinions, memoranda, and importantly, judgments, is the most pertinent to the ICJ. This is because it touches upon how historical materials and arguments influence the interpretation and interplay of formal legal sources. The business of judging, of producing authoritative historical meaning in the form of judgments, is an exercise in historical discursive production. Moreover, this is unavoidable. As David Berriman persuasively puts it, any reference to state practice, to the writings of authoritative publicists, or judicial opinion is a reference to history. And even if resort to those sources is unabashedly instrumental, in the sense that it directs towards the identification of relevant norms or rules of international law, it is clearly an inseparable part of legal activity. Histories written within international law focus on the conceptual and discursive apparatus most familiar to us as lawyers, i.e. legal arguments, and how those arguments are distributed in terms of structures and patterns within our intellectual field. It's this type of history Samuel Moyne and Robert Cole had in mind when, in their respective chapters in the Oxford Handbook on the Sources of International Law, they each argued that history can be seen as an indirect source of legal obligation within Article 38 of the ICJ statute. While not textually present, historical material and subsequently how we interpret that material informs how we ascertain custom, as well as identify the textual meaning of particular treaty provisions. As Cole put it, history is not considered a source that produces rules of international law, but as the great uniting dimension between treaties and customary rules, which history both explains and directs. This has to do with the fact that international law, as a horizontal or decentralized system, is not based on static sources adopted as legislation such as codes, but on mobile or precisely historic sources. Consequently, regarding my first aim, for these reasons, it seems perfectly plausible to envisage or comprehend the ICJ as a producer of not only legal knowledge, but historical knowledge as well. Turning then to the subsequent story. Regarding the second aim, difficulty emerged when I attempted to map the litany of ways the ICJ has engaged with history in its judgments. I started by reading accounts of cases that had already been examined from this perspective, and two examples are worth citing. David Betterman, in a 2007 essay, examined the Kasekile-Sadudu Island case between Botswana and Namibia, which turned upon interpretation of an 1890 treaty between Britain and Germany. And Mika van der Linden, in a 2014 essay, examined the Cameroon-Nigeria case, which turned upon construction of an 1884 treaty between Britain and several indigenous monarchs. The respective conclusions regarding the competence of the ICJ's use of history in each case are quite different. Betterman warned of the need to avoid instrumental uses of history in legal argument, a sin he critically labelled Foreign Office international legal history, itself a play on American historians' critique of law office history. However, Betterman also observed the court had reached a legitimate conclusion by refusing to make a ruling based upon fragmentary and indeterminate archival evidence. In contrast, van der Linden criticised the court for failing to engage sufficiently with the ambiguity and contradictions of the archival evidence, arguing it adopted a biased, one-dimensional and Eurocentric construction of the legal historical context, thereby leading to the wrong material conclusion. What unites these essays, however, is the belief that the court is required to observe the methodological sensibilities of professional history in terms of how it selects an appropriate temporality or periodization when determining context. In other words, in calling for lawyers to seriously engage with history, they endorse the argument that the ICJ either does good or bad history without reflecting on the merits of the contrary, i.e. their own position. As Ann Orford observes, this kind of posturing is overly formalistic and endorses a belief that historical or textual meaning is found in reality as opposed to constructed by the interpreter. These perspectives, along with my own perusal of a select number of historically oriented judgments, gave me pause for two reasons. First, the ICJ is not as ideologically entrenched or as transparently instrumental in its use of history as the US Supreme Court. There is no ICJ equivalent of Clarence Thomas or Antonin Scalia, much less Annalena Kagan or Sonia Sotomayor. Nor does the ICJ, unlike the Supreme Court, regularly receive amicus briefs from professional historians. This makes the task of producing a typology more difficult and requires a greater degree of care to produce a credible description of the ICJ's uses of history. The second finding that caused me to pause was discovery that my initial framing of the typology exercise was flawed in terms of foundational assumptions connected to my third aim. My intention to situate the ICJ and its use of history in the context of international law's turn to history. I'll wrap up my presentation by offering some reflection on that third aim. As at the turn to the millennium, international legal scholarship began to experience what later came to be described as the turn to history. David Cannon, no doubt, will produce a better descriptive account of this event than I possibly could. However, there are two things worth observing. First, from the perspective of my aim of situating the ICJ within that event, it's sufficient to say that the turn to history is generally understood as a reimagination of international law's history as a productive domain of scholarly intervention, argument and critique. While historical interpretation has always been a feature of international legal scholarship, and international litigation, as Sara is going to discuss, the turn to history represented a considerable professional shift in terms of volume of interest and imaginative potential in international law's history. Second, this reimagination has also led to methodological disagreement between international lawyers and professional historians. And I don't want to say too much about that, but I think it's worth summing up some of the fundamentals. That debate has at times been considerably fractious. This so-called methodological war, to borrow the phrase of Natasha Wheatley, has centered primarily upon anachronism, or the interpreting of past events and ideas to the ideas and narratives of the present. Professional history's disciplinary protocols view anachronism as bad history because it does not comprehend the meaning of events or ideas in their contemporaneous context. This debate has reached something of an impasse, as I've learned from reading David's work on this point. I'll not ask him to expand too much more on it, just to say that, that's the credit for that point goes there. And my current reading of this impasse is that one side, a collection of professional historians, has insisted upon the superiority and ethical necessity of contextualism as a practice of interpretation, while on the other, certain international lawyers have insisted on the utility of anachronism for critical legal interpretations of the past. Both positions criticise the failings of the other to learn from their opponents' disciplinary protocols, with international lawyers accused of instrumentalism and presentism, and historians accused of objectivism and neoformalism. And there are a multitude of positions in between these two poles of extremes, but that's the impasse I want to focus on in my final remarks. Something both camps accuse the other of failing to appreciate is that historical and legal meaning are contingent. They're not empirically verifiable, and they're subject to a politics of knowledge within each field. There are also claims of friendly fire and lack of engagement. However, one gets the impression of two entrenched sides speaking past one another. Orford does point out historians' critiques of international lawyers are not focused on standard works of mainstream international lawyers or of mainstream production of international law through the form of judgments or things like that, but critical histories and scholarship in the Twale tradition, which might be seen as a form of policing heterodox interventions within international legal scholarship. However, as Kate Purcell also argues, critical histories of international law are usually opposed to standard histories of international law, rather than history as it is used within international legal argument, i.e. formal legal advocacy and the production of judgment. And that seems to me to be the productive point if one wants to push past that impasse and continue to find a use for history in international legal scholarship. Turning focus towards how arguments regarding time and history are constructed in advocacy, or reviewed and evaluated in the production of judgments, seems like one of the last remaining productive spaces in terms of that intersection between law and history. The object, however, is not to relitigate cases as rightly or wrongly decided, as I fell into, or that being the trap I fell into when first trying to produce this paper, but instead to critically reflect upon expert practices of interpretation and the politics and ethics of expertise, so that we might begin to understand what they say about our engagement with the ICJ as a site of historical production. Thank you very much.
Thank you, Connor, for keeping perfectly to time. So now we have Sara Wissmann, who will soon be defending her PhD and will start as a postdoctoral fellow at the University of Salzburg. And her presentation is titled The ICJ and the Principle of Intertemporality, Rhetorical Fig Leaf or Realisable Promise.
Thank you very much for this kind introduction, Matina. I think I'll stick with the theme that Connor just introduced of a dinner, but I find it a bit questionable whether then I would be the main dish of this panel. Maybe that's for the Q&A to decide. In any case, it is my pleasure to share my reflections on the ICJ and the principle of intertemporality, rhetorical fig leaf or realisable promise. Since intertemporality is classically framed as embodying the dichotomy between stability and change, I think that this presentation aligns well with our panel's broader themes. Connor has already introduced, I think quite nicely, the tension between historicity and public international law, And I believe that David will later address the interplay of duration and evolution. My focus is on critically engaging with one of international law's norms, which I would argue primarily functions as a temporal law identifier, the principle of intertemporality. This principle, as articulated by Judge Schuba in the famous and also notorious 1928 Island of Palmas Award, has two distinct elements. According to its first static element, acts should be judged in light of the law contemporary of their creation. This is quite uncontroversial. Its second element, which surrounds more controversy, in contrast, adds an evolutive turn, distinguishing between the creation and also the continuing existence of a right. Whether a right continues to exist shall be judged by considering the evolution of the law. The second element thus requires us and the law to have immediate effect ex nunc. The principle of intertemporality is often celebrated as a mechanism for safeguarding legal certainty, a community interest, as Sally told us yesterday. But how well does this principle function in practice? Connor has already addressed this question more broadly, but I would like to also revisit it here in the context of pressing global issues, such as the legacy of colonialism or climate change. My central question, therefore, today is whether intertemporality is merely this rhetorical fig leaf, a tool the ICJ uses to project an image of legal certainty, or whether it can genuinely, as a principle, deliver on its promise of clarity and stability. In short, I'll give you my answer now already. While the principle aspires to provide legal certainty, it often falls short. This is because while intertemporality appears neutral from the outside, it is equally open to being instilled with the law applier's politicized temporalities. This step I would like to explore with you this claim I would like to explore with you in 3 steps. First, by highlighting the contemporary relevance of intertemporality for proceedings before the ICJ. Second, by analyzing 2 pertinent proceedings before the ICJ, one of which Connor already mentioned. And finally, by concluding with a critical reflection on the limitations of intertemporality and its implications for international law. First step. To illustrate the enduring relevance of intertemporality, let us briefly consider the ICJ's climate change advisory proceedings. While I'm sure David will delve a bit deeper into this case, I would like to highlight how the principle of intertemporality emerged in the submissions of states. 2 main camps discussed intertemporality in the ICJ's climate change proceedings. The first camp, mostly global North states, emphasized the applicability of intertemporality's first element. It was held that customary international law on greenhouse gas emissions emerged in the 1990s at the earliest. Thus, only from this moment onwards could states be held responsible for their emissions in contravention of the respective customary international rules. This is a clear commitment to intertemporality's first element as reflected in Article 13 of the Articles on State Responsibility. Global South states now, maybe unsurprisingly, opposed this view, arguing that the ICJ should recognize greenhouse gas emissions, for example, as continuing breaches linked to colonial continuities. They urged the court to consider the law at the time of its ruling, referencing intertemporality's second element, today somewhat enshrined in Article 14 of the Articles of State Responsibility. Even though the bench did not, quote, dodge the question of intertemporality entirely, to use David's words in a recent blog post, it is fair to say that it chose to remain silent on the matter of intertemporality, strictly speaking. The court twice explicitly mentioned temporality in paragraphs 97 and 423, twice underlining that temporal questions fell outside the advisory opinion's scope due to its non-adversarial character. Bianca might have characterized this as an avoidance strategy. Judge Nolte's declaration was the sole opinion on the matter, and here we again see the relevance of individual opinions. Nolte dismissed the idea of cumulative greenhouse gas emissions as composite or continuing acts previously argued by Global South states. His reasoning was brief, with the knockout argument being non-retroactivity. While Judge Yusuf's dissent highlighted the global north's and former colonizers' significant role in the climate crisis, the issue of intertemporality was not addressed. However, future litigation cannot escape the relevance of intertemporality, as the court already indicated in its advisory opinion. The two elements of intertemporality show the principle's flexibility, but also its potential for inconsistency, as we will see in the following. This now leads us to the second step of our inquiry. I concentrate here on aspects of two proceedings, Cameroon versus Nigeria, as already mentioned by Connor, and the Chagos Archipelago. The Cameroon versus Nigeria case illustrates very nicely the ICJ's selective application of intertemporality. One of the dispute's core questions culminated in the legal consequence of a treaty concluded in 1884 between Great Britain and the Kings and Chiefs of Old Calabar. At issue was whether the kings and chiefs, through the treaty, ceded sovereignty over their territory to Great Britain. I may make one central point in this regard. The court revealed that when determining the applicable law from the past, European evidence and perspectives are relevant. There is little scope beyond this small circle. Nigeria argued, based on the treaty's language, that the treaty did not transfer sovereignty to Britain, as it was merely a treaty of protection. Her Majesty, via Article 1 of the treaty, extended her gracious favor and protection. In return, the kings and chiefs agreed and promised to refrain from entering into any correspondence, agreement, or treaty with any foreign nation or power, except with the knowledge and sanction of Her Majesty's government. Nigeria explicitly invoked intertemporality both in its written and oral submissions, arguing that the evidence presented showed that the European powers regarded the indigenous rulers as having rights and obligations under international law. Nigeria stressed that the kings and chiefs held the power to conclude treaties and hold territorial sovereignty. Their understanding of the treaty terms should thus influence the treaty's interpretation just as much as Great Britain's. Cameroon, also relying on intertemporality, contended that the treaty did transfer sovereignty, adopting the arguably Eurocentric assumption that indigenous rulers lacked international legal personality. The ICJ sided with Cameroon, highlighting that the fact that a delegation was sent to London by the kings and chiefs of Old Calabar in 1913 to discuss matters of land tenure cannot be considered as implying international personality. It simply confirms the British administration by indirect rule. The court's reasoning was deeply problematic. It relied on colonial-era documents issued by British consuls as the exclusively correct view on the law and ignored the perspectives of the indigenous parties to the treaty. Somewhat apologetic, the court concluded that even if this mode of acquisition does not reflect current international law, the principle of intertemporal law requires that the legal consequences of the treaties concluded at that time in the Niger Delta be given effect today. As Judge Al-Khazavneh commented, this surrealistic interpretation perpetuates the idea that one party to a treaty can unilaterally determine the international status of the other. Yesterday, Alison already stressed this point when she mentioned that in the recent Gabon Equatorial Guinea case, the problematic usage of colonial law based on an alleged usage of the principle of intertemporality surfaced in the individual opinions of Judges Yusuf and Tladi. Abstaining from questioning the superiority of Eurocentric perspectives, creates a systematic bias in law ascertainment, leading to a continuation of historical injustices in contemporary public international law. The Chagos Archipelago Advisory Opinion, though, provides a contrasting example, I would argue, of an application of both intertemporality's first and second elements. Here, the ICJ was, as Alison elaborated on in more detail than I will here, inter alia asked to determine whether the UK's decolonization of Mauritius was lawfully completed having regard to international law. Central to this question was, of course, whether the right to self-determination had crystallized as a norm of customary international law between 65 and 68. Here again, I would like to tease out 2 points. The first one resembles my reflections on Cameroon versus Nigeria, concentrating on the selection of evidence, although with a slightly different twist. The court decided that, to a certain extent, it can rely on evidence post-dating the relevant time frame. My second point focuses on the methods used to identify customary international law. These methods may also post-date the relevant time frame. In the Chagos opinion, the ICJ stressed that it was entitled to rely on documents that post-date the period between 65 and 68, and here I quote, when those instruments confirm or interpret pre-existing rules or principles. Alongside this statement, it assessed the weight to be given to these documents based on the 1996 Nuclear Weapons Advisory Opinion, which determined that UNGA resolutions may sometimes have normative value for establishing the existence of a rule or the emergence of an opinio juris. This methodological approach to the UNGA resolutions was developed only after the relevant time frame in Chagos. In addition, the court clarified the 2 constituent elements of customary international law, state practice and accompanying opinio juris, in its 1969 North Sea Continental Shelf judgment, which, as you may see, also post-dated the relevant time frame. While the components of customary international law were not completely unsolidified prior to the ICJ's North Sea Continental Shelf judgment, they serve as the authoritative focal point, I would say, even though it's good that Sir Michael is not here because maybe he would consider his work the authoritative focal point on the composition of customary international law. These methodological approaches significantly distinguish the court's knowledge in 2019 from that of any actor involved in the 65 to 68 timeframe. Based on these selected sources and the updated methodology, the ICJ concluded, and I think here we all very happily read this advisory opinion, that the right to self-determination had indeed crystallized during this period. While this approach also, I would argue, aligns with intertemporality's second element more generally, demanding immediate effect ex nunc, it raises questions about the court's privileged position as a posterior observer. By relying on legal materials and methods that post-date the relevant period, the ICJ effectively reconstructed the past through the lens of the present, undermining the principle's promise of legal certainty. These case studies thus, I would say, reveal the limitations and inconsistencies in the ICJ's application of intertemporality. While the principle aspires to provide a neutral framework for temporal law ascertainment, its implementation is often shaped by methodological shortcomings, Eurocentric biases, the evolving nature of international law itself, and its second element, which demands immediate effect ex nunc. International judges inevitably struggle to step back in time, and I think we all do. This is not merely a technical challenge, but a reflection on the politicized and contingent nature of temporal law ascertainment. Time is inherently political. How we interpret the past shapes our legal and political responsibilities in the present. Chagos, in contrast to Cameroon versus Nigeria, shows that the principle of intertemporality can also be appropriated by judicial actors to further the demands of colonized peoples. By exposing intertemporality as a rhetorical fig leaf, I do not mean to dismiss it entirely. Instead, what I hope for is a more honest engagement with the principle's limitations. To address the legacies of colonialism, climate change, and other pressing challenges, we must critically examine the temporal assumptions that underpin international law. Thank you.
Thank you, Sarah. So now we have David Scott, who is a British Academy postdoctoral fellow at Queen Mary University, actually working on a project on the turn to time in contemporary international legal thought, who will be presenting today on a topic, on the topic titled Synchronizing the World, Time and Temporality in the ICJ's Advisory Opinion on Obligations of States in Respect of Climate Change. David.
Putting the ICJ for a long time. See if I can arrange all of this one thing. Apologies. And start the timer. Thank you. I just want to echo the thanks for the organisers today for inviting me. It's really lovely to be back in home territory and on such a wonderful panel. I think everyone has pitched me as the dessert, but I'm afraid I might be closer to someone leaving without paying the bill, because a lot of things have already been suggested that I'm going to cover that are not in this paper. So this is very much still a work in progress, and it's part of, as Matina said, a much larger project that I'm still kind of grappling with the foundations of. So I'm really keen for feedback and discussion today. But let me first pick up something that Connor said about history and time. So much of the debate around the history of international law so far has looked like what a good history for law would look like. And my project, in some ways, is trying to think about that from the opposite direction. So it's trying to grasp with how the legal imagination thinks about time normally and why history becomes a productive space within that. So it kind of reverses the way in which law and time are thought about in this juncture. And indeed, this also connects with Sarah's argument that I maybe want to push further and ask, you know, where time might be hiding across international law, not only in the sort of very bright temporalized concepts like intertemporality, but also in the background of the kind of very definition and application of legal obligations themselves. And so it's here that I turn to the ICJ's advisory opinion on climate change, which has been hailed as one of the most significant cases that the court has ever dealt with, in part because of the existential nature of the threat that it grapples with. And indeed, a number of scholars have suggested that climate change is of such a scale and magnitude that it should force a fundamental reorientation for international law. And that challenge has often been posed as specifically one of time. So the discipline of international law has traditionally ran on a linear modernist idea of progress, where we move from a dark past to an at least potentially brighter future under, you know, the tutelage of international law. But climate change threatens to undermine that temporality fundamentally. Where the future had previously felt like an open horizon, climate change has rendered it frightening, a looming and seemingly inevitable threat of environmental collapse that always seems to hover over our present. And under climate change, the past too becomes complicated. It's no longer settled and gone, but continually present in our present. It's something that we can't kind of escape or repair from. And so what this paper tries to do is think about where the advisory opinion might sit within that reorientation of time. And it doesn't get anywhere near towards thinking about that in a large scale, but it tries to break down tentatively how international legal argument detects, registers, articulates, and restructures its sense of time through its conceptualization of climate change as a distinctly legal problem. So what I'm interested in is the move that the ICJ makes when it says there's climate change as an existential threat, and then there's climate change as a legal problem, and what kind of translation has to happen there for that breakdown to happen. So in order to unwind this, the paper moves through three stages. The first looks at existing literature from socio-legal and historical scholarship and draws out some of the ways that law and its distinct and peculiar relationship with time has been thought about before. And it tries to draw these together as a set of argumentative techniques. So I don't want to say that there's only one theory of time, but that rather there's kind of overlapping ways that law rhetorically speaks about time that can be kind of drawn on or put in conflict with one another at different points in an argument. I then make an attempt to search through some bits of the climate change advisory opinion to find where these temporal arguments manifest and how they're kind of resolved by the court. And then finally, I want to draw some conclusions, might be a strong word, but draw some suggestions as to where we could take this forward as a conversation. So turning to the first section of the paper. Section 1 looks at how law has traditionally thought and tried to kind of configure the past, present, and future. And I argue that there's 3 distinct registers through which law's time has been thought about. So first of all, law's commitment to historicity, that's the idea of the past. Its present simultaneity, so the idea that sort of all of law is present at once. And its idea of the futural duration or stability. And yeah, as I've said, these are more kind of conflicting than harmonious. Similar to the famous oscillation between apology and utopia, a given legal argument will often draw from these 3 times at once and try to paper over the conflicts or overlaps that exist between them. And at some stage, what I would like to do is kind of map out how these argument bites sort of work in a legal realist sense, but that will have to await another day. So let's start first with law's historicity. This is a term I take from a US constitutional law scholar called Paul W. Kahn in his book, The Cultural Study of Law. And Kahn argues that law's distinctive relationship to the past is, in fact, what it marks out most significantly from other modes of thought. So political policy, for example, can propose a solution that's focused on the future. In Kahn's words, it's the best outcome, all things considered. Morality or ethics, in contrast, gains its authority from being presented as timeless and universal. So it's the deep abiding rules by which we should always live at any given moment in time to secure the good life for ourselves. Law, however, must always begin with a commitment to the past. It has to speak within the authority of a pre-existing legal order that sanctions that particular argument and on which it can ground its reasoning. Now, in domestic law, that historicity is normally found in a written constitution, something that international law lacks, no matter how hard the Max Planck Institute tries otherwise. But nevertheless, that historicity recurs whenever international lawyers have to establish the existence of a legal obligation. So be that the crystallization of a new customary international law norm, the particular interpretation of a treaty, and those are moments where a particular moment in the past has to be brought to bear in the present. So hold that in your mind. That's the first kind of dimension of law's way of thinking about time, this idea of the past. However, as Connor's already raised, this is not a historical understanding of the past. It's an idea of the past as granting an authority, but we don't actually go and look like historians at what happened. It is merely an idea that sort of we inherit from or ground our next argument from. And so therefore, this authority of the legal system, this historicity, serves as a bedrock for a second temporality, what I call a jumbled simultaneity, where legal rules and concepts can be moved across time and applied from one segment to another through a system of precedent and reasoning by analogy. And so this is what Anne Orford, who's already been cited in the room, talks about the skill of lawyers being made to make meaning move through time. It's this idea that a precedent from 1930 can be creatively reinterpreted in the present. And so from this simultaneity, law takes on both an eternal and a revisable dimension. It has this historicity that grounds its past, but that it's always being revised or repurposed in the application to present circumstances. And this is what Carol Greenhouse calls the false historicity of law. So I'll quote from a paper of hers where she says, reasoning by analogy to precedent creates a false historicity and it can perpetually reclaim the past for the present. In theory, a dispute in 1989 can be resolved by reference to cases from 1889 or 1389. The law thus accumulates, but it never passes. At any instant, it represents totality. It is by definition complete, yet its completeness does not preclude change. And this leads me to the third idea, which is this idea of law's duration in the future and this kind of tension between its history and its ability to change. we once again, through its historicity, expect law to move more slowly than, say, politics. We expect it to set up the rules of the game and provide a legal certainty that we can rely on and through which other kinds of mechanisms of governance can work. But that doesn't mean that it can remain blind to changes. It's not also morality. It has to remain up to date. And it's through this kind of process of finding durational rules and reapplying them in the present that the law can govern or create its own future. And this is why the law rarely explicitly overrules itself. The method through which this kind of creation of the future happens is by finding other pre-existing rules which can kind of trump the seniority of the immediate rule. Through sort of legal work in a Duncan Kennedy sense, we can always create a kind of, or find a new rule that can more deeply embed the answer that law wants to create into the future. So I have a line here that says I'm hoping these categories haven't been too abstract so far, and then in brackets, I'm certainly still struggling with them. So what I want to now try and turn to is to talk a little bit about how this manifests in the advisory opinion, some of the ways that time becomes a significant problem for the ICJ. And from that suggest some ways that time might push us towards thinking about the ICJ's work differently. In the interest of time, which is not a deliberate pun, I'm going to focus on two snapshots of the work that time is doing in the ICJ's advisory opinion. So first, I want to look at how this idea of historicity manifests in the ICJ's advisory opinion in terms of where it finds the starting point for the legal obligations to be applied. And then by looking at the separate opinion of Judge Youssef, show that there were other forms of reasoning that were available that the court chose not to take. And therefore, there's some kind of unarticulated assumption about why the starting point for law's historicity is there and not where Youssef would like it to be, and sort of look at, as Sara flagged, the politics of what those temporal decisions make. And then secondly, sort of continuing from Youssef's argument, I'll look at a brief moment in the court's reasoning concerning sea level rises and the continuity of statehood, where the court does appear to recognize a sort of distinct climate change pressure that required a different kind of legal argument. And just to show that, you know, where the court really resists that in other parts of the decision, there it does kind of signal the significance of the stakes of this case. To be clear, I don't raise these issues to say that the court got them wrong in any way. It's just to try and find some footholds for bringing this conversation forward in our Q&A later. So starting with law's historicity. So in the court's description of the context of the request for the advisory opinion, the court begins in December 1968 with General Assembly Resolution 2398, which the court identifies for the starting point of that context. So it's where the kind of awareness of climate change begins. And from there, the court then ties it to the ongoing reports of the IPCC as recognizing the best available science on the causes, nature, and consequences of climate change. Now, sorry, it's just jumped up a page. While this temporal framing might seem uncontroversial, it was in fact a point of significant disagreement by states before the court. Large polluting states such as the USA, Australia, France, Russia, and the UK had argued for a much tighter temporality, saying that the only relevant rules began in 1992. In contrast, a number of other states more vulnerable to the immediate impacts of climate change argued that it should be understood as inseparable from our shared colonial histories. That's from the Melanesian Spearhead Group, not only because colonialism and racism inform our level of development and vulnerability, but also that the developed position of industrialized states was powered by colonial exploitation. And on intertemporality, I believe Kenya also raises an argument about not applying a principle that predates, but we can maybe talk about that in the Q&A. So in this way, the ICJ kind of walks a middle ground between two positions, one that would have very much limited the responsibility of high polluters and the other that would have expanded it to a much more radical critique of the international order. And I'm aware that I'm running short of time, so I'm going to skip through this. In Youssef's separate opinion, however, he notes that this refusal to engage with the differentiated responsibility of states ignores a number of existing precedents that could have guided the court's hand to a much stronger position against large polluting states. So at paragraph 33, he notes that the The obligation of prevention and customary international law was already generally recognised in the Corfu Channel case and the Trail Smelter Arbitral Award of 1941. And so states should have been aware that this kind of damage could be reasonably foreseeable. So therefore, this is kind of missed opportunity for the court to date its starting point of these obligations earlier. This appears all the more noteworthy, however, when one looks at the way that the court very briefly deals with the question of continuous statehood in the face of rising sea level issues. So it's dealt with very briefly in sort of one sentence in paragraph 363. The court mentions that several participants argued that statehood should be allowed to continue, and the court says, in the view of the court, once a state is established, its disappearance would not necessarily entail its loss of statehood. And in the declaration of Judge Tomka, he points out this entirely overlooks the established rules of the formation of custom. Now, what's most interesting in paragraph 2 of Tomka's declaration is that he states this is a response to the context of climate-induced sea level rise. There's something specific about climate change and the threat that it poses that leads the court to kind of take this differing view. And so I just suggest this is one foothold for where the kind of court very explicitly recognizes the climate as altering the way that law thinks about its rules and actually throws out kind of one of its most foundational principles to ensure that statehood carries on. So, very quick conclusions. These questions, what I hope are not just academic. What I really want to bring out by focusing on time in this way is to bring a deeper engagement with the kind of background role that time is playing, not just when we have a sort of big point about history or the application of, rules across colonial eras, but actually that every single application of a legal rule requires this grappling of which past, which present, and which future we uphold. And that brings forth the real stakes of what the ICJ's advisory opinion means. This is the synchronization that I talk about in the title of the paper. The advisory opinion will now guide action on climate change for the next 10, 20, 50 years. And it's really important that as lawyers, I think we grapple with kind of how the presumptions and background roles of things like time play in the way that we think about climate change versus how other disciplines think about it. And so what I really hope from the conversation and from the other panelists is that we can drill down into how some of those background assumptions can be rethought and can also be challenged through the work of sort of thinking about intertemporality, but also history as a specific engagement with the present. Thank you very much.
It's not working. Okay, now it's working. Okay, so let's start by gathering a few questions. Andreas, we'll start with you.
Yeah, thank you very much to all the presenters for very inspiring presentations. I don't really have a question. I think I have a comment. That was sparked by Connor's remarks, but listening to the other presentations, I think is a theme that can relate to all three of them. And that is, it's kind of inspired by, I dabble also a little bit in comparative law. And I was thinking, if you're thinking about the role of time and history and international law, of course, being a discipline where a lot of different legal traditions come in, can something that you're grappling with also be explained or at least looked through the lens of, through a comparative lens, in the sense of course, always running the risk of it being a caricature, but I would say that in a civil law continental tradition, we're much more trained to think of law, and to some extent also international law, in kind of a revolutionary way, right? So the changes come up with revolutions, like changes of constitutions, really radical changes of legal orders, or the creation of a new law or a new treaty or something like that. Yeah? Whereas I think in the common law tradition, you have much more the historical element is much more built in. That is an evolutionary bit, right? And to add like a second pair would also be that in the continental tradition, you might also think of it more as an evolutionary versus eternal aspect. So that we are more thinking from a principle perspective. That is something that doesn't really have a this evolutionary aspect to it, but is something that is just as a principle to be the point from which we look at it, regardless of the historical trajectory. I know that's a very abstract point, but maybe that might be helpful to look at the questions that you're grappling with from a bird's eye perspective. Thank you.
Yeah.
Thank you. My question's for Sara. On the treaty on the cessation of sovereignty with the Cameroons, immediately brought to my mind, the Treaty of Waitangi and New Zealand's history on that point. And from the Māori worldview, since 1840 onwards, they've been consistent with the view that sovereignty could have never been ceded because it's so intertwined with the spiritual aspect of Indigenous and with the Indigenous worldview. That position, it was the interpretation of the treaty was an impossibility, and that view remains unchanged. From the British point of view, if you're looking at the text of the English language version and so on, and precedent of local courts, it was the view that the Crown is sovereign over New Zealand, but that position has been slowly changing domestically, where we don't have a written constitution, and there's some understanding that maybe there's some sort of dual version of sovereignty, or who has sovereignty over what, and that's changing over time. And I wonder, when you look at public international law, and how things like the cessation of sovereignty today being a non-derogable norm of international law, how that will influence PIL moving forward. I see in the domestic context, these things can change over time, and we can reach a sort of consensus of perhaps what the treaty originally intended, but rather than being some sort of intertemporal law being more brutal as it's currently being used.
Thank you, Francisco Sindico, University of Strathclyde. So I have just two quick questions on the climate change advisory opinion. You rightly said at the end that this has very practical implications, and I fully agree with you. It's a question, but also just food for thought. Curious whether in the bigger project, you said this is part of a bigger project or a bigger idea, the relationship between temporality and the so-called carbon budgets. So when a country has a specific amount of emissions that it can emit, and so forth and so forth. And this, at least to me, has massive implications for domestic litigation, the Liuya case, the Holcim case in Switzerland, but also obviously in possible future interstate disputes, now that we have this very rich normative tapestry, if you want, with not one, but three, potentially 4 advisory opinions come next year with the African Court of Human Rights. Second point, and this is a question to everybody in the room who has more experience than me before ICJ. I think one of the greatest things of this advisory opinion has been its transparency. If somebody has the time, I don't, but if somebody has the time to go through every single thing that is available online, you can have incredible information from anything from St. Lucia to the UK to Russian Federation, all sort of things is there. Where there was a lack of transparency is what happened the week before the oral proceeding started, where the judges were in a closed room with IPCC people/members. Now, maybe that happens all the time. I don't know. So this is a question both to you and to everybody in the room. Is this normal? Because the deference towards the IPCC touched almost religious standards in the advisory opinion. It was more than just best available science. Whatever they said was true. And I'm not saying that's not the case. IPCC is considered like that. But what did they say? None of us council had any clue what was in that room, what happened in that room, what were they saying. And in a process where usually you find everything and you can comment on it, that to me was a little bit awkward.
Any more questions for this round? Yes.
Thank you, Athena Richford. Thanks for a great panel. I suppose really to David, and it was just kind of picking up on your final point about the idea of the climate change case being this kind of, or the synchronizing point, right? And I'm just wondering from a genealogical perspective, whether we might start to see this as a point of departure. And if that's so, then considering the separate opinion of Judge Youssef, whether we start to see paths not taken and whether that could have ongoing significance. I suppose just as an aside to Connor, whether, because I firmly attach myself to a genealogical approach, whether you think that that might be useful.
I think that's enough for one round, and I will start with David, and we'll go around, and you can also comment on the comment by Andreas, and whatever you think is relevant to your.
Sure, thank you. Yeah, already great. Where to start? Francesco, I'll start with yours because just so. No, unfortunately, I'm not looking at carbon budgets. This is part of a project that's also looking at the kind of turn to history, and it's a way of thinking about different times in international law. So there's history, past, present, future. I do think that's really interesting, though, and is something like this paper is also trying to lean towards, because I think generally there's been some really good writing on the management of risk more generally as a futural concept. I know that Jeff Mann is doing work on that currently, which is really interesting because, I mean, that's due diligence, right? And it's sort of precaution. It's this idea of what kind of future do you imagine, and then science playing a very particular role there. So all of which to say, like, I would throw that open. I would be happy to hear from anyone else about that work. It's not something I'm taking forward as of yet, because I'm more interested about how sort of the present of climate change is conceptualized, I guess, by scholars and by people who write about it. But it's, yeah, super interesting. And then Athene on the genealogy. So I had an answer, and now it's just slipped out of my head. If it doesn't come to me in a second, I'll pass the mic on. And yeah, I mean, I think we were talking about this actually over dinner last night, like Connor and I, that I think it is notable that the ICJ has this. So I didn't actually get to it. It was the only slide I was going to put up. But there's that paragraph right at the end. It's the last substantive paragraph where it says, like, it's a legal problem, so we can answer it, but it's also an existential problem that is much more than we can do. And again, I like looking around the room, people much more qualified to talk about the ICJ than me, but that does seem like a hesitancy that you don't normally see to be explicitly. I mean, I don't know, like, I haven't read nuclear weapons in a while, or the ones that would be parallel. But like, if you think about like the mid-2000s, like the European Court of Human Rights is writing about how they're going to constitutionalize Europe and everything's great. And so there is something, maybe there's a sense of like climate hesitancy there that I think is interesting. That's a different genealogical point in that there is definitely the genealogy of how these practices will sediment, but there's also the genealogy of like what that hesitancy, well, that moment of hesitancy might signal and where that might go. And I don't know what work can be done with that in future. I don't know if it's good to signal that there's a limit. And so that's the throw that I'm kind of interested to hear from people who work more with the ICJ about how significant that is, because it's definitely the thing that struck me most from reading the final advisory opinion.
I'm going to address the questions or comments, maybe both in order. So first, Andreas, thank you very much for this hint to a comparative lens, which I, in the broader project, did pursue to a certain extent. So even though maybe from a slightly different angle than you did in your comment, I understood you to refer also more to the like interpretive value of like originalist approaches versus evolutive approaches. And I was interested more in, you know, the origins of intertemporality. Like, is it a principle? And if so, can we establish it via comparative view? So yeah, thanks a lot for that. You kind of confirmed my perspective on that. And then Stefan, yeah, the Treaty of Waitangi, I think, is a very interesting and exceptional case, I would say. I mean, we talked about this in private conversations, you know, that I looked into the Treaty of Waitangi and New Zealand and the Maori, because I found that very interesting. I found, in my opinion, they had found a solution to a certain extent, which is also politically influenced, I think, in order to deal with their exceptional situation in New Zealand, or your exceptional situation in New Zealand. Do I think that this could influence public international law moving forward in relation to intertemporality and how we identify the applicable law? Yes, I do think so, because there is currently a very strong discourse surrounding intertemporality, and I think it is moving the principle. So the discourse branches out into different fields. Some tackle the first element of intertemporality, others tackle its second element. But here I think it's important to stress that in relation to the first element, we have scholars such as Mamadou Hebie, for example, or Matthias Goldman, who really do quite in-depth research into these like sources, archival research as well, and to try to identify the role of indigenous peoples in relation to certain treaties. And the more the awareness, I think, grows on the international level, the more states might cautiously be willing to also be more inclusive in terms of like what was the applicable law and who holds the power to interpret the law. And here, yeah, we can maybe see that already in relation to terra nullius. It probably already happened, because how Huber defined terra nullius in the Palmer's case differs quite strongly from the ICJ's take on terra nullius in Western Sahara, for example. So we already, I would see a shift in relation to certain concepts. But when it comes to treaty interpretation, like the authority might still lie a bit stronger with the parties, and here the European parties, I would say, to these historical treaties.
All right. So I'll take mine in kind of chronological order as well. Albeit for no reason, it's just the easiest way of doing it as opposed to the theme. So Andreas, yeah, no, so I really enjoyed your comment in terms of that sort of the idea of international law as composite legal traditions, and how that, or being a product of composite legal traditions, and how that kind of produces tension. I think in terms of that debate I was talking about, Anne Orford, because we mentioned a few times already, explicitly kind of references that kind of lawyerly ability to make meaning move across time, and doesn't identify it with either particular tradition, but does highlight that the common law tends to be more historical because it's based largely on precedent. And what that kind of makes me think of is a similar intervention from Jonathan Sumption, a former justice of the UK Supreme Court, in a speech from about 2013 titled "Historian as Judge." And for context, he was a historian before he was a judge, and what he kind of does in the speech, besides kind of identifying how being a historian or having historical training influenced his ability as a common law judge to weigh up those kind of evidentiary traditions, he kind of lamented the fact that conventional English legal education in the 19th century included training in history. Oxford School was set up as a school of history and law, and I think in terms of those common traditions, I don't think there's that kind of schematic split in civil law traditions as far as I understand them. Certainly, speaking from my Scots LLB, there were certainly modules you could take that would imbue with that sense of historical training. So I think there's definitely a productive space there. But listening to David's talk, I think kind of what it kind of made me think of, in terms of how you talk about that narrative between lawyerly training and historical training, is they're almost kind of competing theories or comparative theories of periodization. The issue is not so much that historians and lawyers are disagreeing necessarily as to content, but necessarily we draw the context. Where are we drawing that temporal moment from where we include a certain real principle of law or a certain particular practice, and how that influences our ultimate conclusion. Athene, so just briefly on that point, yeah. Do I think genealogy is a productive space or a productive tool to use? Yeah, certainly. Kate Purcell has this great Ejo piece from 4 or 5 years ago, commenting specifically on this debate and giving both sides a kind of a good dusting in terms of treatment, but kind of cuts through that by saying, well, the productive space of genealogies, it cuts through the kind of the issue with both sides. You know, it's sufficiently respective of contextualism. It balances this idea that we have to have appropriate reference to context, but it also allows us to track meaning across time. Certainly, I draw genealogy in my own work, aside from this particular paper, my kind of own historical and archival work. So yeah, definitely think that's a productive space for sure.
Thank you, everyone. We have time for another brief round of questions. And Joseph?
Thank you. So my question is, it's more something prompted by Francesca's question and David's answer, which is in terms of thinking about time and thinking about experts and expertise, in particular when we divide up the time into the past and the future, with legal expertise sitting somewhere in the present at every single point. And in particular, the idea of the past being something that belongs to historians and the future being something that belongs to scientists, essentially. And it's the problem is that that's where the question runs out precisely at the point when I should be formulating it better. But it's sort of how does, I suppose the question is really, how does expertise and the idea of expertise shape how we think about time?
Okay.
Questions? Thank you. My question is for Sara. You put intertemporality and its workings very much sort of at the level of principles, and here's Uber, here's state responsibility, and I think I found that very helpful. I was wondering whether in your research, because it's so focused on what courts do, have you come across, let's say, other factors, and one in particular that I have in mind, the temporal limitations on the court's jurisdiction that often require a particular point to be identified, let's say, after the entry into force of the treaty, or I don't know, a cutoff point is defined in one way or the other. And do you have the impression that that very technical factor shapes the handling of intertemporality identification issues by courts in those disputes? For example, suggesting that something must be a continuous breach so that it comes within the jurisdiction, or conveniently saying that it is an old breach so that it can be left to a side and avoided. I'd be curious whether you've looked into this, and if so, what you found.
Thank you very much. International lawyers often become these kind of jacks of all trades. We do a bit of climate science in the advice opinion and history as well. And we have really no methodological training in many of the things that we do. Are we particularly bad at history? Or just bad at history, maybe not particularly bad.
Okay. And the last question.
Thank you. I have a question for David, because I was kind of expecting you to touch upon like the future generations in the context of the ICJ advisory opinion. And I was thinking that like, I always see advisory opinion as rulings for future, like for future perspective. And I was also thinking that in many passages you mentioned, we see how clear the present influenced the past. But with the future generations, we have kind of confronted with the opposite problem. So how can, or if it's desirable to use like past/present categorization of law for addressing future generations problem, future generations position, subjectivity also, I don't know. Or, I mean, I was just curious about your stance on this one. Thank you.
Thank you, Veronica. So we'll also read one question from the audience online. So this is from Alan Ware, and she's asking, could one or more of the panelists comment on temporality and the rights of future generations? Do the findings of the ICJ advisory opinion on nuclear weapons and the advisory opinion on climate change in particular point to an emerging norm that human rights are now transtemporal and transgenerational, meaning that future generations share the same or comparable right as current generations? So that's all, and we start in the same manner.
Thank you. Yeah, big questions. I'll admit future generations I sidestepped kind of deliberately because I was initially it's not an area, this is the thing I'm expanding into as well, doing environmental law. So not an area I understood where the kind of waterline was before. And I thought that the advisory opinion seemed remarkably kind of non-committal. And then I saw some blog posts being like, this is great, and some blog posts being like, this is terrible. So I kind of have deferred looking at that question until, I mean, I do think I think what I would maybe push at is, I'm forgetting the name now, but the Against Future Generations piece, thingy, LSA, Stephen, it's terrible, I'm forgetting his last name. Humphreys, yeah, that's kind of where I lie on it. It's like, yeah, they're trans-temporal, but also what does that mean? I actually don't think that's that significant, because I think a lot of law is trans-temporal anyway, and so how much talking about future generations instantiates something new, I'd be really interested to know more from people that work on that, but I don't get the sense that, I get the sense it's just making explicit something that is latent in a lot of human rights law anyway. This idea of duration and stability versus evolution and change is like present in any human rights or any legal concept anyway. And so that's been some of the conversation that I've picked up on, is the debate around whether the advisory opinion is good on future generations will all be based on how it's interpreted by domestic courts or future courts. How do expertise shape time? I mean, yeah, I think there's a lost thing that was really interesting around the sort of like when people got sick of talking about neoliberalism and were trying to work out new ways of talking about it. There was some really interesting stuff about like data being can predict, so predictive policing, but also predictive science generally. And this idea that neoliberalism wasn't just about selling an individual consumerism, but it was about creating data points that could kind of predict that future society that we kind of just like lost. Then like COVID happened, fascism's happening, and now it's like, I feel like we did lose, there was like an interesting conversation there. Dimitri van den Meersch, a colleague at Queen Mary, is doing really good work on this in the context of AI borders, so border security and technology, and specifically the challenge that poses to the kind of liberal idea of like the transparency and like the moment of decision. Like if we're all doing the Schmittian thing of being like there's a decision maker, and that is actually gone when you have like a system that builds stuff. And so it's a bit rambling, but I think there is something about how, because it's not just that scientists predict the future, right? They are using data from the past. So it actually is a cannibalization of a bunch of stuff that flattens into one time. And then you're getting into, I mean, that's then circular time, it's eschatology, right? Like science will re-govern the past until the God and the machine comes out, and then we'll have like full utopian whatever on the moon. I'm aware I'm not doing that thing where it's like a rambling answer, but I think there is something about how that like science stuff is actually taking us back to a kind of prefigurative like pre-modernity, but that's a much wider conversation. I'm going to stop talking about techno-futurism now. So thank you.
Thank you, Christian, for that question on principles and, my court focus and the question of critical date and, temporal jurisdiction. So you asked whether something came to my mind in relation to that, a case probably, and of course, jurisdictional immunities comes to my mind, Germany versus Italy. I don't know whether you were involved in that, but here we saw in that case probably that Italy tried to kind of argue continuing breach in order to move certain acts into the temporal jurisdiction of the court. So yes, I would say that intertemporality, and they argued based on intertemporality as well. So I would say that intertemporality is definitely shaped by temporal jurisdiction and vice versa. In my broader research, I was not only interested in what happens at the ICJ, but also the actors around it. And one of these actors is, of course, the International Law Commission, inevitably. And here I looked specifically into their work on the Articles of State Responsibility, but also on the VCLT. And interestingly, especially the question of jurisdiction, ratio temporis, as it was developed within the European human rights system, influenced the anchorage of intertemporality within both Article 14 of the Articles on State Responsibility, but also Article 28 of the VCLT as we know it. So like in my broader research, I tend to take a more socio-legal approach to intertemporality, and I kind of try to map how the discourse shapes it, how precedent, for example, influences how we see intertemporality today. Yeah, so I'm happy to have a private chat later on that.
Okay, so I'll just come on that sort of last question is are lawyers particularly bad at history? And I think it kind of touches upon in Joe's question a little bit as well. And I would do that kind of classic conference thing of not providing an answer to it, but reframing it. I don't think it's necessarily a question of good or bad. And I think when I started writing this paper, that was my impression. I was going to come in and go, I'll tell you what, this case is an example of bad history. This case is a good example of good history. And I don't think that's productive. And I think it kind of gets bogged down in that kind of debate I was trying to sketch. And the way I would kind of describe it, or if one was engaging in that approach continuously, I think it does kind of become a sort of discipline and policing without sufficiently kind of taking on the protocols and imperatives of the discipline that you're trying to effectively police. And Samuel Moyne, in a chapter in the Oxford Handbook on the Sources of International Law, sketches this out quite well and frames a lawyer's approach to history and a historian's approach to history is trying to fulfill two different aims. A legal advocate, when presenting historical evidence, is trying to win a case, so trying to persuade a judge of a particular point of view, while as a historian, when conventionally looking at the same topic, isn't trying to do that. They have a much longer period in which they can draw information from. They're not trying to persuade to win a result of no one reads the book. No one reads the book. That's sad for them, but it's not going to determine the outcome of a case. And I think it's whether or not you can reconcile those two competing aims in the context of, obviously in this paper I'm planning to kind of look at litigation, but whether you can reconcile them more generally. And I think where that kind of comes into, and we kind of revert back to that point, and I don't feel bad for not kicking it any further because Sam doesn't kick it any further either, is can you reconcile those kind of two competing forms of expertise? I think when you say this is good, bad history, or bad history, it kind of tends to present one or the other as being objectively true, which when the actual kind of more insightful point from either side is that both legal meaning is not inherently indeterminate, but it's contestable, it's subject to argument, but so is historical interpretation. We don't have access to the past, so we can argue about what it meant, but we have to argue about it. There's no kind of definitive answer. And once you see someone kind of presenting that as a definitive answer, then there's kind of something more ideological or political going on there. And I think that kind of suspicion is kind of where I would kind of find my place in the fence and sit there, honestly.
Yeah, I'd forgotten about that point on the are we bad historians? I mean, like history departments are also collapsing, right? Like I'm not being flippant about it. I think there's also a kind of interdisciplinary divide, and I don't mean that in the way of we're learning from each other's method. There's literally like their colleagues are getting their department shut down, and I mean, this is like, it's much bigger in the US, but there's been so much writing on the sort of crisis of history and also like literary studies. There's the Professing Criticism book that basically maps this as being a sort of, universities had a lot of money in the 60s because they were funded for, Cold War research, and that bubbles burst. And so there's a fight going on that is also, there's methodological stakes, but there's also like labor stakes. And then I think there's also something, not to be like I'm doing it, but I'm speaking about this at ESOL on Thursday. So if you're Friday, so if you're around, like you can see the sequel. But there's also something about like history goes through that crisis at the moment where law is actually kind of unleashed from stuff. Like the end of history for international lawyers was a great moment. That was like human rights are coming, we're getting like all the power. And so the crisis happens later in the turn to history. Like they're not just asking different questions, but they're on different tempos and different parabolas and wavelengths and whatever visual metaphor you want to use. And I think that is also one of the reasons why the spat is happening, because people don't get, those are the bits of Orford's book that I like, where she's saying that history was actually a response to these things in law. And if historians don't get that, like that's fine, but they're different things. And history is going through a particular crisis that it can't get out of. That, yeah, I don't think we take account of that enough. So sometimes the thing of like, are lawyers bad historians kind of presumes that the historians are good historians and like are really healthy and the grass is greener over there. And actually, I think if you went to a history conference, they would have a very different view of how we're doing here. Not being a downer end the panel, but.
Okay, thank you all for a very excellent panel and very good discussion. And from looking at the law and how we think about the law and the meta aspects of the narratives and time, and as well as how it applies in the context of the ICJ and how it's utilized. So bridging this gap between theory and practice. So I don't want to stand between you and lunch will be provided outside, and we will be back at 2 sharp, please. So that's all I have to say, and now you're free to go. But please, a round of applause for the panel.